Hello, welcome again to our discussion on the case of Nnamdi Kanu. My name is Emeka Ogbonye, and this discussion is occurring as a continuation of some discussion we have held in the Due Process Advocates group. In our group, we are concerned about law and development. That is our key concern. And you will all agree that today in Nigeria, the case of Nnamdi Kanu, the founder of IPOB and ESN, is the most important case in Nigeria. It is something that is so serious that anybody involved in legal topics, in legal discussions, in justice topics in Nigeria, and the world perhaps, should be interested in the case of Nnamdi Kanu. It's a long story, but I just want to highlight a few things. First and foremost, let me emphasize that this case is so emotional because it is connected to Biafra. Anything involving Biafra, as you know, is highly emotional. So, it is not possible to discuss this topic without offending some people or without saying something that is not what people expected you to say. But in my case, I have agonized over the controversy or over the fact that this is a very highly polarizing topic. It divides the people. It makes enemies of some and makes friends of some. So, as I do this, let me issue a disclaimer in advance. I am guided by my view of the law, not by the sentiments of the case. I am constantly aware of the difference between what the law says and what I wish. Unfortunately, not everybody can distinguish between what he prefers or what he wishes and what the law says. So I'm going to give you my view and my opinion of where the law stands in the context of the case of Nnamdi Kanu. As of today, we are just beginning to confirm that Nnamdi Kanu was actually taken from Kenya and from Kenya to Nigeria. Initially, it was not clear where he was taken from. Some rumors said it happened in Brazil. Some rumors said Czech Republic. And finally, it says Kenya. But even the Kenyan source is controversial because the Kenyan High Commissioner to Nigeria actually addressed a press conference and he denied categorically that Nnamdi was taken from their country. An ambassador is such a senior official of a country. It is difficult to dismiss him. However, Nnamdi Kanu's lawyer, Ifeanyi Ejiofor, states severally that his client was taken from Kenya. And he had had access to his client, Nnamdi Kanu. I believe that if Nnamdi Kanu said he was taken from Kenya, it must be from Kenya that he was taken. So, the question at this moment is, what is the next step? What do we expect to happen next, given all that had happened so far? In other words, we must take what happened as what happened. We are no longer wishing they could happen differently. He was taken from Kenya and brought to Nigeria. There had been so much said about his rights, given the circumstances in which he was taken and brought to Nigeria. Ejiofor in his interviews suggested that he will make a case against Kenya and international law. That's not true. That's not how the law works. Individuals really has direct access to international law claims against countries. Very rare. There are exceptions. But I don't see how this becomes an immediate relief to Nnamdi Kanu. The fact is that he is in Nigeria today. So we will be looking at what would the Nigerian law do to him? What would the Nigerian processes and procedure and the Nigerian courts be expected to do? On Tuesday, when he was taken to court, right after he was brought into the country, 2 days after he was brought into the country, it was surprising that they did not notify Nnamdi's lawyer. They ought to have notified him. If you're taking somebody to court on a case that has been outstanding, and a case in which it was clear he had a lawyer, you owe a duty to inform his lawyer. You cannot present him before a judge without notifying his lawyer. That happened, and that was surprising, and that was inelegant on the part of the Nigerian government. And you have to understand, Nigerian government has to understand that in dealing with a case like Nnamdi Kanu's, the government must follow the law strictly. If the government deviates from the law and infringes the rights of the accused person, that could be devastating to the outcome for the government perspective, because it will strengthen the contention of the accused person that he is being persecuted and that his rights are being denied. So it is baffling to me that they did not notify Ifeanyi Ejiofor to be present in court, that his client will be in court. The government may argue, I have asked myself, what could be the possible argument of the government? They could say security reasons, there will be too much crowd in the court, and the crowd could be disruptive, and there could be a riot, given all that had transpired. These are logical reasoning, but they will not be sufficient to prevent them from notifying Ifeanyi. Indeed, they should notify Ifeanyi, but warn him of the consequences of there being disruptive mob activities or crowd activities. They could, I believe, that it is in the interest of every lawyer, both Nnamdi's lawyer and government lawyers, that the trial should proceed without disruption by crowd or riot or anything. So, there is no excuse for not notifying Ifeanyi. And someone may ask, but what is the consequence of not informing Nnamdi's lawyers? The consequences are serious, as you saw what happened. Because Nnamdi was not represented in court, or rather because his lawyer was not in court, Nnamdi was asked to address the court. That is something that is not normal. Nnamdi was not in the best place to address the court, to explain his absence or his failure to appear in the court in the past. Also, Nnamdi was not able at all to speak to the question of where he should be detained. The DSS lawyer basically requested the court that Nnamdi be detained at the DSS facility. And that was it. Nnamdi was not able to address that or to refute that or to challenge where he was being detained. It would have been better for Nnamdi's lawyer to be present in court to address that issue, even though one can fairly assume that the court would not have done otherwise. The court would probably have ordered that Nnamdi be detained at the DSS facilities, given the circumstances of the case, given the sort of facts that should have been put forward or argued by both sides, assuming there was a lawyer on the side of Nnamdi Kanu to controvert the request for him to be detained at the DSS facility. So that is gone. Another question was, when will be the next court date? The court fixed 26th of July. That is a fairly long period of time. It could have been shorter. And there was nothing stopping Ejiofor from applying to bring the date forward He could apply. A lawyer can always go to court and file an application indicating emergency, requesting a hearing, and the hearing date could be brought forward. I don't know if he has done that or what he plans to do about it. Another concern I have is, it is very possible that this year's judicial vacation period will start before the 26th of July. Assuming that happens, that means that this court will be on vacation on the 26th of July. And unless this court is the administrative judge, unless this judge is the admin judge that doesn't go on vacation, that may mean that there will be no hearing on the 26th. And that means that Nnamdi will stay in the DSS facility even longer beyond that. But let us assume that a trial proceeds or the court sits on the 26th. What are the likely things to happen in court? This is what we expect, or what we think should happen. Nnamdi's lawyers will make two applications. One application is for their client to be granted bail. In other words, they will be asking the court to vacate the order revoking the bail previously granted to Nnamdi and to reinstate the bail already granted. Okay, if the court agrees to do that, in other words, if the court says, all right, I hereby reinstate the bail that was previously there, assuming it happens as straightforwardly as that, there will be additional question whether all the sureties are still available to remain the sureties. We heard recently that one of the sureties for Nnamdi Kanu had gone to court requesting for his money to be released to him. In other words, if that happened, he will no longer be a surety. Nnamdi will be prompted to provide another surety. That is, if the court were to say, okay, I reinstate the terms of bail. But also, the court may reinstate the terms of bail, or may reinstate bail, but with new terms. The court could require new terms, impose new conditions of bail. The second thing that the lawyers will be asking for, and I believe they will ask for it in the same application, will be for their client to be remanded in prison custody instead of the DSS facility. Will that happen? Is that likely to happen? I don't think so. I don't think so. Even if the court decides or refuses, if the court refuses to release Nnamdi on bail, refuses to grant bail, the court may choose now to remand him at the DSS facility instead of the regular bail. There are many reasons for that. Though these reasons have not been argued before the court because we don't know whether the lawyers have been able to put forward appropriate affidavits and appropriate arguments to brief the issue. If they do, I expect the government lawyers to argue that Nnamdi is highly dangerous, that he coordinates remotely a militant group, that he was able to stay in London or outside Nigeria and establish ESN and coordinate activities and issue orders, that if you kept him in the prison, he will have too much latitude and could pretty much continue to run something like the ESN from within the prison. That the prison doesn't have the facility to completely shut a person up from the world. That on the contrary, DSS has that such facility. That if you keep him with them in the DSS facility, Nnamdi will be completely unable to communicate with his followers, either verbally or by sign language, directly or indirectly. So this argument is going to carry weight before the judge. So the judge is going to say, well, these things are serious. And usually in this sort of case and in this sort of charges, the DSS will come up with some argument of secret intelligence sources that provided information not readily available to people, and judges tend to defer to that sort of argument. Judges tend to defer to the credible argument of intelligence agencies that there is something special, there is something really hidden, known to them, which they cannot make available immediately, suggesting imminent danger if certain things happen. If that occurs, the judge is going to defer to that argument, and the fact is that the judge is going to allow for Nnamdi to be detained at the DSS facility. Also, DSS is going to come up with the stories about new charges being investigated by the EFCC, by the DSS. Remember, by the time Nnamdi was granted bail in April of 2017, that was in relation to his arrest in October 2015. So one of the things the lawyers would have said, or the lawyer said, I personally saw the application for bail, and I knew it was said that the investigation has been completed, that there was no reason to keep him detained because he was no longer in a position to interfere with investigation that has been completed. He made an argument, it was a very valid argument, that after 1 year, 6 months, after 18 months in remand, in incarceration, that Nnamdi was no longer in a position to interfere with the investigation because the investigation were deemed to have been completed. That was valid. But that argument will not be valid today because the government is going to argue that they just got him. They will say that between 2017 and 2021, which is 4 years,